Let's now look at the doctrine of sovereignty from a global perspective. When UK became part of the European Union in 1973, the Conservative government at that time assured the citizens that the principle of parliamentary sovereignty will not change. However, European Communities Act of 1972 has reordered the constitutional arrangement of UK. If we look at the Section 2 of the Act, it provides that European Community law should be given effect in UK. As we have seen previously in Costa versus Enel 1964, it was established that in the event of a conflict between the European Community law and the domestic law, European Community law prevails. Taking the constitutionalist view, we can lay out the argument that EU law only supersedes the acts of Parliament because the Parliament has given this power to EU law through European Communities Act 1972. This situation can be contrasted with the constitutional arrangement of France, where the Parliament is restricted by international law. Or Germany, where the Parliament cannot enact laws that are not bound by a moral code. The situation is very different in UK, where in theory the Parliament is not bound by any constraints in enacting legislation. The idea of a Bill of Rights or human rights is directly related to the idea of entrenchment, which basically means, can the Parliament restrict its power to enact legislation in future? This question creates an interesting paradox. If the Parliament is truly sovereign, it can legislate in any way it wishes. But on the other hand, if it does restrict its sovereignty, it will not remain sovereign. With the enactment of Human Rights Act, the courts are empowered to declare an act of Parliament incompatible if it is against the European Convention of Human Rights. Again, taking a constitutionalist view, we can argue that the Parliament is sovereign and it has incorporated convention rights into English law through the Human Rights Act. This takes us to the second question in our discussion of human rights and the doctrine of parliamentary sovereignty. Should there be a British Bill of Rights? Professor Geary talks about a British Bill of Rights and why such an idea is not in the best interest of UK. He states that the current situation of human rights is a dialogue between the Supreme Court and the European Court of Human Rights, quoting, "The UK needs to be part of the European system of human rights, which consists of the European Conventions on Human Rights." He further states that staying in the system is in the interest of every British citizen because then they will be protected by one of the prominent systems of human rights protection under the umbrella of Universal Declaration of Human Rights. The Human Rights Act does not affect the sovereignty of the Parliament because the judges can only declare a statement of incompatibility and the UK Supreme Court has the power to negotiate the rights with the European Court of Human Rights. On the other hand, the British Bill of Rights may restrict future parliaments in enacting laws that may be contrary to the new British Bill of Rights. The court will also lose their power in interpreting the rights, and the dialogue between the British and the European Court will cease. Before we end this discussion, I would like to state the facts of a case that shows how the courts look at the sovereignty of the Parliament and human rights. In R versus Secretary of State for the Home Department ex parte Sims, the case dealt with a ban on prisoners who were not allowed to speak with journalists. The ban was a restriction on the freedom of expression, thus making it a human rights case. The Court of Appeal found the ban to be unlawful. Hoffman said, "The parliamentary sovereignty means that the Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act 1998 will not detract from this power. The constraints upon its exercise by the Parliament are ultimately political, not legal. But the principle of legality means that the Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implication of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. In this way, the courts of the United Kingdom, though acknowledging the sovereignty of Parliament, apply principles of constitutionality little different from those which exist in countries where the power of the legislature is expressly limited by a constitutional document.